Welcome to the Agent Legal Lounge, the ultimate interactive weekly webinar that answers your burning real estate practice, contract, and legal questions. Hosted by distinguished attorney John George, co-chair of the Texas Real Estate Commission Broker Lawyer Committee, CEO and General Counsel of Special Provisions, and managing member of George PLLC. Tune in each week for an exciting, laid-back, and incredibly informative hour as John explores the Texas real estate profession, tackles hot topics requested by brokers and agents, and even takes your questions live. Get ready to dive in. The Agent Legal Lounge starts right now.
What we're talking about today are the new proposed TREC contract changes. At the August 19th meeting at TREC, they approved for comment all these changes that the Broker Lawyer Committee's been working on for several years now. We try not to make changes too often to the contract, and because of the compensation issue, we held back on some of the other changes that we otherwise would have pushed through. And so if you want to see the actual changes in red lighting format that we're going through today, you can find it at that website that's on your screen. If you Google TREC rules, it would bring you right to this website, and you'll see the screen that's on the PowerPoint before you now. And then right there with the number 2 arrow, if you click on those attachments, it will open up the PDF that has these nice, easy to read red lines that you can see the changes real easily. There at the 3rd arrow, if you want to provide comments, that's where you click on if you want to comment on any of the changes. The comment period is open up. We have a meeting on October 11th on the TREC Broker Lawyer Committee that will consider all these comments. And then it would go before the TREC Commission at their meeting on November 4th with any changes that we suggest making, or if we end up pushing through the versions that are out there now, they'll consider that along with all your comments. And when you click on that comment page, this is what it looks like. You get to leave your name and what your role comment is, and you can even attach documents if you want. And we don't get many of them. A lot of tomatoes are thrown at us sometimes, but you can leave nice comments too. We like reading those. And just to give you an example, this is from our last meetings in July. We had 2 meetings in July, and these are all your comments. We read every single one and go through every single one at our before our meetings, and then address those concerns during our meetings, which are also broadcast live. So we'll go to the changes that are before us today, right? These are the ones that are out there for public comment that the commission approved for everybody to look at and to give their feedback. I'm really excited about this survey change. So if we look at the first one in paragraph 6, this is a screenshot straight from the red line version of the contract. No, there's going to be no more hunting down notaries for T47s. A T47 before had to be notarized, both signed and notarized. Well, Texas law has gotten with the times to say notaries aren't necessarily needed in every case. So they said now an unsworn declaration can satisfy the notary requirement, where essentially your client's just signing with some magical legal language. Texas Department of Insurance has a rule that should be passed very shortly that allows that to be on the T47 form. You didn't know T47 is a Texas Department of Insurance form. So they need to change it, but the intention is for them to change this up to allow unsworn declarations, meaning no more chasing down notaries. And that's important because the language, as we clarified, you'll see below, if you check box C1, you have to get both the survey and the affidavit to the title company. It's not just one or the other. It has to be to the title company. And if you didn't have it notarized before, it wouldn't suffice. So that's going to be a big change, I think, in the logistical practice that gets with the times. Another big thing on the survey paragraph is that we've had a request for a long time for the buyer to have an option not to get a survey. And in our TREC 1 to 4, there wasn't that option. And there's many reasons for it, but we've now inserted or suggested an option for no survey. And it's by changing one word in that paragraph C2. And you'll notice there on the right-hand side where that red arrow is, we changed shall to may. And that then allows the buyer to elect to get a survey. But if they fail to get a survey and their lender denies property approval because of it, we're not going to give them an out in the contract. So it's going to allow them to not get one, but we're not going to allow them under the Third Party Financing Addendum to terminate the contract because of that survey that failed to do it. So I think those are two really good changes that have been requested for a long time. Jumping forward, I don't know if anybody's heard this yet, but broker's fees are not set by law and are negotiable. We can't say that enough, and it's good that it's in here, but we've added that statement. I don't think we need to dwell on that because hopefully you've all taken many classes to get up to speed. What I think you're more interested in hearing about is what are we doing in the contract for buyer agent compensation? How are we addressing that in the new TREC forms? Well, we made a very simple change that hopefully will be easy to use in practice. And this comes in paragraph 12. And so paragraph 12 is the seller, where sellers can contribute a certain amount to buyer's expenses. The problem before is buyer's expenses did not include a compensation to the buyer's agent. So what we did was add as a new subsection that you'll see there in 12A1B, that's the section right here, that allows the seller to contribute an amount to be applied to brokerage fees that buyer has agreed to pay. And then you have an option for a percentage or a dollar amount. And so if you see in the blue box down there, it allows the seller to contribute an amount specifically for buyer broker compensation. Subparagraph C operates like the old contract did, where the seller can contribute to other buyers' expenses, right? So some sellers may not want to contribute specifically for buyer agent compensation, but they're still willing to contribute for all the historical buyer expenses, the loan fees, the long laundry list that we'll see on the next slide. So we broke it out into two paragraphs. There's been a question about why did we move B to C and why it may be confusing. The justification behind it at the meeting when we were talking about that is to have the catch-all provision, the amount to all other buyer expenses being at the end. We thought that made logistical sense, but let us know your comments on this. Let us know your thoughts. This is something where in the contract itself, the seller can make an offer for to pay some amount of buyer agent compensation. And then of course, we kept the procedure for all other types of expenses. Now, keep in mind, the farm and ranch language did not change. The farm and ranch language that has been in there a long time, where there's a ratification of fee on page 10, and then an agreement for payment of commissions between the buyer or seller paying for the broker fees, that's still in the TREC contract. We did not remove that. There's a lot of discussion putting that in the 1 to 4. There's 11 hours of meetings. That's a lot of detailed discussion on that you can watch online. But we ultimately, at this point, decided not to suggest that for the 1 to 4 and the other contracts outside of the farm and ranch. To make sure that this was something that to all the other documents were in line with this change, we updated the amendment form. So even though you may have it in the original offer that the seller will pay a certain amount towards buyer agent compensation, that can change. Just like almost everything in the contract's negotiable, that continues to be negotiable afterwards, right? So if you're in the option period, or you're outside the option period, and you're trying to negotiate repairs or something, this is one element, buyer agent compensation, that is still negotiable. So this, you're locked in, the seller doesn't have to agree or the buyer doesn't have to agree, but this gives you the ability to amend it after the contract's been executed. Down below, you'll see there in paragraph 12A2, this is the definition of buyer expenses, right? This has been in there for a long time. I think a lot of people overlook the defined term of buyer's expenses, but it ties into the amount that the seller is contributing for the other buyer's expenses. And we merely added a section in there that describes brokerage fees as being part of the expenses. Of course, it's not an other expense, it's a specific expense that the seller will be contributing to under this prior one right here, right? So you have contributing specifically for buyer agent compensation. And then all the other buyer's expenses, which are listed right here, are what the seller is contributing for in the other box. And one thing to note too, there was a form of this language out there circulating from the original TREC materials that in 12AC had a mistake in the red line. TREC has updated that on their website, but you might have intended some presentations or had some materials produced to you that innocently had the wrong language copy, but TREC has updated that on their online forum. But just know if you see some other duplicative language in there, that might be the reason why. One thing to wrap up this compensation side of it is that the disclosure at the end of the contract, on page 9, the compensation disclosure has been changed. It removed the reference to the MLS, but it still operates the same way. It's not binding. Keep in mind, this is not binding. At one point, we suggested taking this out because there's arguments whether MLS agreement controlled or the numbers put in this paragraph controlled. And historically, if you had a property in MLS, that absolutely controlled. And so instead of taking it out, we put it back in and put a disclosure at the end saying, this is informational purposes only. So keep in mind, if you put any amounts in here, it's not binding. You can't create a binding agreement there. To have it fit more the typical situation, we, instead of just having a blank, we insert it there. You'll see in blue a checkbox for whether it's a dollar amount or a percentage of the sales price. So instead of just having a blank that had sometimes some odd numbers or percentages in there, we had it more closely match the other parts of the contract and how agents were actually using that provision. Okay, so we quickly went through compensation. I'm sure we'll probably circle back around to that at the end if we have time, but I want to get through the other changes today. So there's another long time request for us to develop a 1031 exchange addendum. There's sometimes a lot of confusion between the parties when one side or the other is doing a 1031 exchange. And the reason for that is there's additional paperwork that needs to be signed. And there's a qualified intermediary that's involved. That sometimes if you see the documents, looks like it's being transferred to that property, and that can confuse people. So this addendum is designed to give notice to the parties that one side or the other is going to do a 1031 exchange. And it's a very common procedure. And so this gives them notice up front that, hey, this is what we intend to do. And essentially the agreement in B you'll see there is that the parties agree to play nice in the sandbox, like how I'd like to say it, that they agree to reasonably work together. But at the same time, the party that's not doing the 1031 doesn't need to incur any additional liability. In the closing, they agree won't be delayed because of the 1031. So we're not going to allow the extension of any deadlines under this addendum. We're not going to create any additional liability for the person that's not doing the 1031. But we want to give notice and the requirement that they'll reasonably work together on these forms that must be signed to actually accomplish the 1031 exchange itself. So the next one we have is in the vacant land property. And the ones we went through generally apply to all the contracts unless I state otherwise, and I may miss one or two, but this one's a change that's specifically for the vacant land property contract. And it is in regards to paragraph 3D. It's an addition, a new paragraph 3D, and it adds the sales price adjustment that's currently found in the farm and ranch. And how it operates, it says that we believe the acreage is X. And there's a blank there, third line down, where you put what you think the acreage is. Now, this won't be fitting, and you won't necessarily use this for a lot that's lot and block that's vacant land, or for maybe even small acreage. This is not a mandatory use. All right, so you can check will not if you're not using it. But when you're dealing with large acreage, the parties sometimes base their valuation of the property or their estimated value of the property on the actual acreage. And so if you want to, as a buyer, say, I believe the acreage is X, but if it differs in the survey, I want the sales price adjusted. Well, this provision allows you to do that. And it's just like the farm and ranch has been in the past, but now we've extended it because it logically makes sense to do it in the vacant land as well. So you would put what the adjustment will be. So you have an amount for the acreage, and then if it's off by 5% or whatever percent it is, then the sales price is automatically adjusted if you elect to use this provision. And it has another little catch at the end that says if it's adjusted by more than 10%, either party may terminate the contract. So let's say there was some reason that the the acreage was way off, and the parties didn't anticipate that. And if it's way off by more than 10%, the parties have a right to terminate the contract in this provision. The last one at the end you'll see here that has a checkbox whether the change in the amount will be made to 3A or 3B. That's in regards to whether it's made to the cash portion or the finance portion of the contract. Or proportionally to the two. So you won't have to do a second amendment. We went ahead and put into the contract exactly how the adjustment will be made to the 3A and 3B provisions. This next one's another one that's been requested for a long time, and I have to give credit to Diane McCoy she's on the broker lawyer committee for really pushing this one. We formed a subcommittee, we looked at this for a while, but she was really the driving force to analyze the backup contract addendum and to make this real good logistical change. And so effectively what we did here was provide an option for the parties to require the buyer to pay additional option money and additional earnest money when they go in the first place. So a lot of times when a buyer says, I don't want to put up this large amount of earnest money and tie it up, or I don't want to pay this larger option fee that the seller's requesting, but I'm willing to pay it once I'm in first place. And a lot of times agents were trying to write in language that they shouldn't have, that's legal in nature. It may not have covered the basis, or they've had attorneys that put the language in, or whatever reason. Here we're providing a vehicle for that logistical situation to be accomplished in the addendum itself. So if the buyer wants to put X dollars for the option fee and X dollars for earnest money right up front when they sign the contract in the backup addendum, and then hopefully they go in the first place later, then they can say, well, I'm going to put this amount more in this amount more in option money. The rest of the legal language there, if you go through it, is meant to accomplish a couple things. One is to say, let's say that second payment becomes due. What if you don't pay the whole thing? What if the buyer is short on the total amount of the earnest money and option fee? Well, we want to protect the option. It's a very important right. It's a draconian penalty if you don't pay it because you don't have an option. So we said if there's a shortage of money, we're going to have it applied first to the option fee and then the balance to the earnest money. Well, let's say if you don't pay that balance of the earnest money, or you don't pay the earnest money at all that's due when you go in the first place, what happens? Well, it's just like in the existing contract right now that the seller has a window of time to terminate. So the seller can terminate the contract until you pay that earnest money. And you make up the shortage or pay the full thing. And it looks like it's a lot longer in there, but we wanted to make that clear. And that's already in the underlying contract for the original option money and the original earnest money, but we wanted to spell it out. So it got a little wordy in there, but we thought that was necessary here to make sure everybody understood exactly how it operates, all within the addendum itself. And just remember, if you don't pay that option fee at the end, you don't have the option. So you have to, as an agent or as a buyer, stay on your toes. Agents, stay on top of those deadlines. Make sure that when you go in the first place, you're having that option fee paid within the time required. And you get to choose the time required under this addendum, right? There's a blank there. So if you know your client might be out of town at some point or it's hard to get a hold of, build in that time into this backup addendum. Don't just put a very short amount of time that you just assume your buyer will pay it. Talk to them about how, logistically their situation and how long they need to do it if you end up going with that option. Okay, a lot of this stuff has been stuff that's been asked for a long time. I've been repeating myself on that, but this is another big one. And this is in paragraph 2A of the Third Party Financing Addendum. And it's the requirement for buyer, when you have buyer approval issues, when the lender denies buyer approval, they didn't qualify for the credit, they couldn't get the loan that was listed in the Third Party Financing Addendum. Historically, they just said, I couldn't get it. Lender denied coverage. I can't get the loan. And sellers and listing brokers were like, well, wait a minute, show me proof. And a lot of times you knew that was just a false excuse. They wanted to terminate for some other reason. And sometimes it was explicit, but they used that as an out. What we did here is to mirror some of the language that's in paragraph 2B already regarding property approval that says, okay, you had that termination right, but you have to show me some written documentation from the lender. So not only do you have to give notice within the time period that you put in the contract, but you have to give that written statement from the lender. And so this is just saying no longer do you have to just trust me, you have to provide some documentation of it. I think that's a great change because I've seen this provision used many times as kind of another option type period. And if they were called to the mat later, buyers use that way improperly, they could be called to the mat and sued by the seller. But practically, that's hard to do in residential real estate. So this is providing a more clear way to establish or satisfy that concern up front. And I guess one last point before I move on from that, there's no prescribed nature of notice that needs to be provided from the lender or the lender's written denial. Right? Just like in paragraph 2B, there's frequently a question of, well, what does a lender statement need to say? What form does it need to take? We're not prescribing that in the contract. And so it can be, multiple different types of notices or different written denials, but you just need to make sure it's in writing and provided to the other side. Sticking with the third party financing addendum again, we have the change to paragraph 2B, the property approval section. And what we did here was more of a clarification. There was a question under the old language, whether if you had an example I have on the screen here, you had a Friday closing date. And it said in the old language that you must terminate not later than 3 days before closing. And so was that not later than? Did that include the Tuesday in this example, day 3, or not? Did it have to be on Monday or the Tuesday? So the language that we changed up now says on or before the third day before the closing date, or on or before the third day before the closing date. And so it makes it clear that in the situation on the screen, that Tuesday is a proper day to give notice. Again, it's both notice in the written lender's written denial of the property approval. So it makes it clear that the Tuesday is an appropriate date to give that notice, to remove the issue before where there was an argument whether it had to be the Tuesday in this example or the Monday. So going back up into the contract, we have changes that generally are in all the contracts that is paragraph 6, title notices. And this falls in a category of don't forget, right? There's a lot of title notices built into paragraph 6. And those title notices are prescribed mostly by statute, what the Texas legislature says sellers must give notice of. And what we added here is one that's been a requirement for a long time, but just wasn't in the contracts. We had TREC had a Sunset Commission review that went in and said, let's look at all these seller disclosures and what's in the contract and what's not. This wasn't necessarily the focus of that, but it's part of the same vein of let's be complete, more complete. And so we added the certificate of mold remediation. The law has been the same for a long time that if a property's has been remediated for mold, the seller has to provide the certificate if it happened during the preceding 5 years. So this is just another notice. Don't forget, this is something you have to provide. Now, one that's admittedly confusing for everybody, including the lawyers that practice this, is some of the required notices like the MUD notice, the water control notices, the public improvement district notices. That's a topic that can take up hours in the class. But what we did here is to try to change the language up to tell them that there's some rights that the buyer may gain to terminate the contract if these notices aren't provided. Just for a quick example, if the property is located in a MUD district that requires the notice to be provided and is not provided before the contract's executed, that buyer has an out all the way through closing. On the public improvement districts, if the property's in public improvement district and the notice isn't provided, the buyer has an out all the way up until 7 days after the notice is actually provided. So there are some major penalties for the seller if these notices are provided up front. So we added some language there to reinforce that, so to let the the seller know, to give you as an agent a vehicle to point them to of this is why it's important. This is why when we're doing the listing appointment and we're talking about this, let's get this up front. And we also changed the language on how we describe the notice a little bit too. But again, this change falls in the category of please don't forget, and give you something to talk about. And Kirsten, I see your hand up there. But
when you're done,
what's the question on this one?
Are we almost? I've got 2 questions for you when you're ready.
Yep, we're almost done. I'll march through these last couple here, and then we're going to try to stick to this 30 minutes. So I'm going to try to wrap this up pretty quickly. The other changes that we have here this is in paragraph 4. We just added geothermal to the list of natural resource leases. Right, this doesn't change anything. There's a lot more circling around in Texas about geothermal energy, which is heat energy from the earth. So we just added that to the list of what is a natural resource lease. Didn't change the substance, just an addition. Same thing with just an addition that's been a requirement for a long time is in the farm and ranch. You'll see that paragraph 20 in all the contracts used to say federal tax requirements. Well, we're remove the word tax, and now we're putting federal requirements, and we added in the farm and ranch the Agricultural Foreign Investment Disclosure Act requirement for sellers who are foreign persons to provide notice to certain agencies, when they're buying or selling property. So this requirement didn't change, but we wanted to add that to the contract to have it explicit. So those are all the big changes. There's a few little wording changes in there that are minor in terms of substance. I know this was a lot today. You can hop on our Facebook and YouTube channels. If you haven't already liked and subscribed, please do. We'll post all these videos and continue to bring them to you every week and address other things. But please send in your comments to these forums too. We really appreciate and need your feedback. We read everyone and really appreciate everything that you do to help us do our job.
Okay, John, can you go back to the slide with paragraph 12? Their question is about 12C, if that is chosen. Is there an order in which the fees are paid in case it doesn't cover all the buyer fees? Let me think through that one. 12C, is there an order in which fees are paid in case it doesn't cover all the buyer's fees? The one thing I'll mention is you do have that separate buyer rep agreement, and that is an agreement between the buyer and the buyer's brokerage. So elaborate on that.
Well, so C is for other buyer's expenses, and there's no prescribed order in the contract. So C does not apply anything to broker compensation.
I got to stop you because you're sounding prescribed. Define that for me.
So thank you. Get out of my lawyer brain here. So the contract does not require the contribution to be applied in any particular order for other buyer's expenses. So, but if you put in here an amount in B, so B versus C, if you put an amount in B, it's only going towards buyer, applied to broker's fees that buyer has agreed to pay, right? So that would be in that other buyer's rep agreement that hopefully you have executed up front, right? That's in B, it's specifically going towards that amount. If you put something in C, which is like the old provision, other buyer's expenses, there's this long list on this page of what is, if you go right here, what is other buyer's expenses. So everything that's not a fee that the buyer has agreed to pay their broker, that's listed in here is an other buyer's expense. So if you use C, it's going to pay those items, but the contract itself does not require that it go to any particular item first, right? And lenders might require it to be paid. Some you can't use the contribution to pay, so they might, in practice, require it to be used for something first. But ultimately, the contract itself doesn't tell you which one to pay first with other buyer's expenses. But remember, buyer agent compensation and other buyer expenses are 2 separate subparagraphs.
Okay, 2 more questions. One is, tell us the timeline of when we'll actually be able to use these, what the process looks like from here.
Thank you, and I should have said that up front. So what we're doing in these forms, we'll come back on October 11th the broker lawyer committee to consider all the comments. And even our own opinions have changed over time on the committee. If you watch our meetings, they changed over time. So we'll review it then, and we'll make either pushing forward what we have now or additional changes to the commission. That will go in front of the commission on November 4th. On November 4th, if there's no substantive changes and the contracts are approved, then that's when they're formally approved by the commission, but they won't necessarily be available right then. Right? Those would be, we'll have no further comment period if there's no substantive changes. It could go forward if it's approved there. But with all these changes and to get the forms formatted and properly done and in the right channels online and elsewhere, it likely would be right at the beginning of the year before we actually have them in our hands as agents to use. It could happen as early as November 4th. So you may have heard the statements out there in the conversation, but ultimately what Chelsea Buckholz said at the Texas Realtors Conference when we gave panel presentations, most likely be the first of the year before they're actually in our hands.
Yep, because it takes a minute for them to roll it out to Zip Forms and all the different software platforms that we utilize. We'll
review the chat if there's any more questions there, and excited for everybody to join us. Kirsten, thank you again as always, much appreciated. Fabian, thanks for all you do behind the scenes as the silent guy working the magic back there. So I appreciate all that, and we'll see you next week. Take care.